you can leave at this point in time. No harm will come or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
Pop my shit, yeah, I'm pop my shit. Nigga been having, you ain't got it like this. Young nigga be hating, you ain't got it like this. What's happening? Back active, huh? Back active with another video. And look, man, I told y'all what the motion was gonna be with Gunna wanna, man. And then there was a little commotion in the courtroom, man. It's crazy, man. He went up for the third bond hearing, and it didn't go too well in the courtroom, man. But you know, I told y'all in the previous video what was gonna happen. But before we get into all that, you already know what the motion is, man. Hit that subscribe, hit that like and that comment, man. Cause we on the road to 5K, 5,000, man. I need that. I know it's a extensial amount of subscribers for right fast, but we gonna make it happen, man. That's my goal, and that's what we gonna do. And we well on the way of doing it. I ain't throwed off by nothing. Everything has been going well as far as subscribers go, and I appreciate y'all. Cause you know, once you tap in over here, you know what you are. You know what I mean? Cause we think with uncommon sense perspectives over here. So you know what you are when you tap in and hit that subscribe button. You are now officially a part of the Uncommon Sense. Yeah, gang, where we slide on the dummies. We slide on the niggas that ain't using no common sense, man. They just yapping and don't use no facts, no, you know what I mean, thinking outside the box to come to a logical conclusion. And that's what we gonna do. And that's what we talking about today, man. Logic with this Gunna wanna shit, because it's a high emotional situation when you in court and going to jail and all that, all those type of legal problems going on, especially family members and stuff. It get real emotional, but you got to remember to use your logic, man, because that emotion will start to just grow and flare out, and that thing, you know, you're yelling out in the courtroom like what a family member of Gunna's or somebody on Gunna's side did, man. You got to see it. But we gonna tap into a couple reasons. I got the video showing you what happened in the courtroom and why they not let him go. They keep denying his bond. Cause exactly what I said, threats. They're using the word fear. He's gonna send somebody to hurt somebody, or they love Gunna so much somebody's gonna do something. But I told y'all in the last video, and you missed that, go see that. Yeah, but let's tap into that video and see what the fuck's really going on. You did.
Your Honor, at this time, there's been no change in circumstance that would warrant the defendant getting a bond. The only thing that has happened since the court last denied the defendant's second request for a bond is that in Henry County, he attempted to obtain habeas relief. That was denied, and then he appealed that to the Georgia Supreme Court, who then denied his appeal for the denial of the relief, of habeas relief. Mr. Kitchens was a participant in Overt Act 75, and in looking at the new indictment, I do see that his name apparently has been inadvertently left off, but that does not in any way mean that the state is now suggesting that he was not a participant in that act.
So there's a new indictment, and Gunna name is not even on the indictment. Man, look, man, they really have no reason. They have no reason to be holding Gunna. I can see why niggas is yelling out in the courtroom at the judge for denying this man bond. It is no reason to keep this man in jail. His name is not even on the new version of the indictment. At least that's what they just said. Crazy, man.
This is a case wherein we have circumstances involving attempts to serve witnesses who frankly break down and cry out of fear that harm will come to them if they are required to come into court and testify.
That is testify against Mr. Kitchen or testify as in
general, Your Honor. I will not say that we have told them you will have to come and testify against Mr. Kitchen specifically. We have evidence that there are members of this organization that are named in this indictment who have in fact, conveyed their willingness to whack or to kill a person for the defendant. And given that there has been no substantial change in circumstances, we would ask that the court deny the defendant's motion for bond reconsideration.
Now, when you mean the last statement you made, whack or otherwise, who are you referring to? Are you referring to Mr. Kitchens? You referring to Mr. Williams? Or who are you referring to? Or the
Specifically, one of the other co-defendants expressed, asked that the defendant Kitchens be made aware that he would be willing to whack somebody for him. And that's just what was found in the evidence that we've been going through so far. We continue to sift through the evidence. Statements like that cause us concern, for, you know, the real threat of witnesses feeling in some way influenced, pressured, intimidated. But even if it is not a request from Mr. Kitchens, hey, go out and do harm to this person on my behalf, when there are people who may feel like it would do him well to have things done to other people on his behalf, and they're gunning for, you know, favor in his eyes, those type of things cause us a real concern. So we would ask that the court, based on the fact that there has been no change in circumstance, deny the bond reconsideration motion.
okay.
Your Honor, can I, that we are once again getting this vague information, all by virtue of proffer.
Okay, but
And
a proffer is authorized
I understand.
under Title 17 at this point in time. It's a different standard than
I understand.
trial standard of beyond a reasonable doubt. And you all know, being seasoned advocates, that the state has to prove these assertions beyond a reasonable doubt at trial, as pursuant in the indictment.
Judge, I'm not questioning their authority to proceed by way of proffer. And in fact, that is the only thing that was decided in the Henry County habeas, and the Supreme Court denied review. I'm pointing out by proffer, and the reason it's important in this case, Your Honor, is this is what has happened now at three different hearings. They've gone by proffer. It's every single time they've made a proffer of the evidence that supports the state's view that there's a significant risk of danger. It's been disproven. The proffers are not reliable. They can proceed by way of proffer.
They have no reason to keep this man locked up, bro. Nope. On no level. Except ain't nobody going nowhere until we start this trial. We're not letting no one YSL member out nowhere. I don't care how innocent they may seem. I don't care we holding them and we really don't even have a reason not to give them a bond. The reason we ain't gonna give them a bond is because we just gonna hold them. That's what's going on, man. And that ain't the end of it, man. Watch this, man.
The context that the statement was made in, and I do not want to, I would be happy to reveal to defense counsel and to the court, not publicly, whose phone it was found within and more specifics about that. But it was simply, I believe, one co-defendant wishing this defendant a happy C-Day, if I'm not mistaken, and imploring a person to tell Gunna that this person would whack someone. I would still whack someone for you. So it's not that we're asking that the court deny bond based on that text alone. It's just part and parcel of the reasons why we're asking that the defendant not be granted bond based on this third request made by defense counsel.
Okay. Anything else, Mr. Samuel?
Your Honor, I'm alleged to have done anything. I mean, I suppose I could say I would do anything for my good friend Brian Steele. I'd do anything for him. And then the next thing you know, Brian Steele gets denied bond because I said that? That doesn't even make sense to say you're going to be denied bond. You'll spend, the better part of 2 years if this case goes to trial next year. It doesn't end until the end. A year and a half because someone else said that they would do something. That's not even an additional reason for bond. And the prosecution says we are relying on all our previous assertions. The previous assertions have all turned out to be hollow.
Okay, all right. Anything else? I just gotta do what I gotta do.
Did you peep that? Did you hear what the judge just said? I just gotta do what, and he didn't even say I guess I gotta do what I gotta do. You know what that means. It's already told to him. He ain't tell the man he was lying, you're wrong. He just like, hey, I can't argue, right? It really ain't no reason to be holding, man. But I gotta do what I gotta do. And that's to keep this nigga locked up. Crazy, bro. Well, let's just see what he say, man.
All right, Mr. Sato, anything, sir?
No, Your Honor, thank you.
Okay, all right. Here's where the court's kind of, where I think all of you are kind of stuck between. There is the standard for bond, which is the preponderance of the evidence. And then there is, and that proffers are authorized by our state Supreme Court for bond. They are not offered or not authorized unless otherwise agreed to for trial. And that strict burden or strict proof is required for that particular proffer as a result to a issue of proof at trial. So we're stuck in between the two burdens in this case. We also acknowledge the fact that, you know, the defendants are presumed to be innocent, and this particular system authorizes the court to consider bond based on statute as well as case law, and and I have done so in this particular case, and will continue to do so. The other challenge that our imperfect system kind of just hasn't figured out a way to kind of deal with, other than reconsidering the issue of bond and changing circumstances of bond, is acknowledged for proof that may or may not come at trial, but the state bears that burden at this point in time. And it's not a perfect system in the sense that we won't know until that time whether or not many of these statements that have been proffered by the state come to pass or come to fruition. That's no consultation or consolation for your client, Mr. Samuel and Mr. Sadow. And but unfortunately, that's the best that the system can offer at this point in time, given the status of the case law and the like. The only thing I can potentially do is, like I said, I will try the case as expeditiously as possible. But at this point in time, I don't find any change in circumstances that would allow me to, or move me from changing my decision as to bond. And if anybody's in the gallery,
you heard somebody say something in the back. The barber said, "Fuck that stupid ass job." I don't know what they said. They said something, but he finna beam in on him right now. Look how you looking at him. Look at his face.
You can't otherwise control yourself, or otherwise you want to make any appropriate comments, then you can leave at this point in time. No harm will come, or nothing else will occur. But if you remain in this courtroom and make any outbursts, I'll have you arrested.
There you go, man. Golly, Gunna. So, let me just explain a couple things real fast. Like, look, bro. First of all, those proffers and stuff, that's just lingo for, at this point in the case, I can go above and beyond to prove that Gunna has no reason for getting out. He dangerous, or he can stir people up. I can go way over the point to try to prove that. That's all a proffer is, and they can use them at this point in the trial before the trial even begin, like pre-trial type shit. You know what I mean? That's all it is if you don't get what that is. But my point is this: they have no reason to be holding Gunna, man. except for what they've been saying. If you peep the words they use words like threats, danger, fear. Those trigger words. Those the words that's keeping Gunna and anybody in YSL locked up, because those the words the state are using to make the jury and the judge and everybody be like, hell no, so they can hold them boys in there until the trial begins. That was their plan from the beginning, and they just thought everybody was gonna be thugged out and fucked up with crazy records and have all this crazy stuff going on, and Gunna beat the odds. And he ain't the only one. Your boy, rest in peace to him. He passed away. He didn't get locked up either. He was a YSL member. He did not get locked up because they say they couldn't find them on him no more than a driving ticket. Same thing with Gunna. So you can't say everybody was in them actions. They're basically already proven that Gunna was not in that motion. And I've been saying that from the beginning. That's why I say free Gunna wanna. I feel it vibe. He is not with that shit. He's just a high profile artist on that label. You know what I mean? But the real uncommon sense point is, I feel the family members are mad because they emotional. But you gotta have to already kind of expect it. Even though these folks ain't right and they have really no reason to hold them, but they're playing this game, and like even the judge said, it's an unfair system. Run it back, check it. He said that. That's a real thing. It's an unfair system. So if I was Gunna cousin and stuff, like I said in the family member, I would have said, like I said in that old video, I would have had some hope that he would have got out. But I know for a fact the way these folks playing these games, he ain't getting out. They're gonna deny everyone's bond. So don't take it personal, fam.
Nope.
Don't take it personal, Gunna wanna fans. It's just, like I said, I hate he caught up in that, man. So when it comes to Gunna getting out and using logic over emotion and learning law, please use some uncommon sense in this common situation when people get caught up in legal situations and got to go to jail. Outie.